10 seconds, 5 seconds, start. As we have directed for deletion for the same reasons, we also set aside the judgment of the High Court whereby it has declined to interfere with the grant of liberty by the DRAT. This being the only prayer by Mr. Jan, it is answered in the affirmative in his favor by stating that such grant of liberty was not within the domain of the tribunal, regard being has to its limited jurisdiction under such special legislation, and further, especially when the bank was not a party to the compromise. Before parting with the case, we are obliged to deal with another aspect. DRAT is required to adjudicate the matter in an opposite manner. It is hearing an appeal from an order passed by the DRT. It cannot afford to pass a laconic order. Learned counsel for the auction purchaser endeavored hard to impress us that the order being a new one, this court should set aside the same and remit the matter to the DRAT. The said prayer has been seriously opposed by Mr. Jan, learned senior counsel for the appellant bank, and Mr. Dham, learned counsel for the borrower. Two aspects weigh in our mind not to take recourse to such a mode, namely, are the auction purchaser has not challenged the order passed by the DRAT before the High Court, nor has he come to this court, and further, Mr. Jan has restricted his argument only with regard to grant of liberty, and with the efflux of time, the bank has realized its money and the property has changed hands. It can be stated with certitude that it is absolutely unnecessary to direct the DRAT to proceed with the appeal de novo. Hence, we refrain from adopting the said course. Resultantly, the appeal is allowed to the extent indicated herein above. In the facts and circumstances of the case, there shall be no order as to cost. The appeal is allowed as for the provision of the law and procedure enshrined in various acts as such. Reliance was also placed by the learned counsel for the appellant on the judgment of this court. Quashing of a case is different from compounding. In quashing, the court applies it, but in compounding, it is primarily based on consent of injured party. In this context, we may fruitfully refer to the objects and reasons of the act. The relevant part of it reads, the financial sector has been one of the key drivers in India's efforts to achieve success in rapidly developing its economy. While the banking industry in India is progressively complying with international prudential norms and accounting practices, there are certain areas in which the banking and financial sector do not have a level playing field as compared to other participants in the financial markets in the world. There is no legal provision for facilitating securitization of financial assets of banks and financial institutions.